Episode 2, on Acme Ghanaian Court Decisions. Welcome to the Law 360 GH channel. Today, we are continuing with our journey by bringing to your doorsteps the Acme Ghanaian court decisions that, to our view, serve as pivotal to the constitutional regime practiced in Ghana today. Today's focus is titled, The Governing Judicial Decisions on the Scope, Enforcement, and Applicability of Article 181 of the 1992 Constitution of Ghana. We therefore wish you all the best as you embark on this journey with us. Commencement. Faro Atlantic Co., Ltd., VRS. The Attorney General on Article 181. Sophia A. B. Akufo, JSC as she then was. The Constitution is the supreme law of the land, and Article 1:1 makes it clear that the powers of government are to be exercised in the manner and within the limits laid down in this Constitution. As the supreme law of the land, the Constitution is applicable at all times, and all acts and things, particularly those done for and on behalf of the Republic of Ghana, must always be tested against its provisions. In the course of judicial proceedings, it is incumbent upon every judge to keep its provisions in mind to assure compliance, not only by the parties before it, but also by the court itself. Had the Court of Appeal considered Article 181(5) critically, it might have realized that, taking into account its language, the overall effect is that, as with loans, international business or economic transactions to which the government is a party also require parliamentary authorization. Where the Constitution stipulates that parliamentary authorization shall be required for certain transactions, then any transaction to which the provisions are applicable that is concluded without the authorization of Parliament cannot take effect without such authorization. I agree with my esteemed brother Dr. Dateba that there can be no doubt that in this case, the agreement was an international business transaction. Hence, it was not enough for the Court of Appeal to dispose of the issue raised by stating that, if parliamentary approval was not obtained, it appears to me, it was because the appellant did not evince any intention of honoring the agreement between the parties in the terms sought by the respondents, that is by amending the PPA to reflect the change in the generating plant. The fact still remains that, as a constitutional issue, it is a fundamental one which we cannot ignore. Indeed, had it not been introduced it one way or the other, we would have been duty-bound, as a court existing under the Constitution, to raise it suo motu and directed both counsel to address us on it. Article 181(5) specifically deals with international business or economic transactions, rather than loans. When one contracting party agrees to supply and the other party agrees to purchase and pay for the thing supplied, is there not a business transaction? I believe there is. And if the supplier is a non-Ghanaian entity and the party of the other part is the government of Ghana, it is an international business transaction. The provision then becomes applicable, regardless of whether in the view of the Ministry of Finance, or any other person or institution, it does not. The applicability of constitutional provisions is not optional and is not predicated on any person's opinions in that regard. MRS. Wood JSC. As she then was. The salutary and well-known general rule of law is that where a point of law is relied on in an appeal, it must be one which was canvassed at the trial. But there are exceptions to this rule, the question of jurisdiction being one of them. A jurisdictional issue can therefore be taken or raised at any time, even for the first time, on appeal. Another exception is where an act or contract is made illegal by statute. The plain rule is that where an action is brought on a contract which is ex facie illegal, it is the duty of the court to take the point, even though it may not have been raised by the defendant. Transactions, even if viewed from the angle that it is merely a contract for the supply of electric power, and not a loan, is an international business or transaction to which the GOG is party, which given the unambiguous provisions of Article 181, 5, needed parliamentary approval. Perhaps a more direct authority on the point is Snell v. Unity Finance Co. Limited, a case in which a somewhat similar question arose for consideration on appeal, namely, whether the finance company were entitled to raise the question of illegality, notwithstanding that it had not been pleaded or argued before the trial court. His Lordship stated the guiding principles as follows: where the Court of Appeal was satisfied that there had been an illegality, it was bound to take the point on its own motion, even if neither the parties did so, and in such a case it must apply the overriding basic principle of public policy that the courts would not assist a plaintiff by enforcing an illegal contract. Again, the well-established general rule is that where the legal question sought to be raised for the first time is substantial and can be disposed of without the need for further evidence, it should be allowed. Substantial constitutional issues, such as the one raised before us, falls neatly into this category. An appeal against an award of damages is by way of rehearing, and one of the grounds upon which an appellate court may interfere with the award is upon proof that the trial judge acted on a wrong principle of law. The proposition established by Henri Mahmoud and Isfahani is that the plea of residential judicata cannot apply to illegal contracts. The PPA is not an illegal contract, but the underlying principle in Henri Mahmoud is also valid for contracts which are void for constitutionality. In that case, the action arose out of a contract for the sale of linseed oil. The court ruled that since the buyer did not have the necessary license, the illegality of the contract precluded the court from granting judicial relief, even though the innocent party was quite ignorant of the buyer's breach of the defense regulations. Scruton L.J. in his speech said, "The court is bound, once it knows that the contract is illegal, to take the objection and to refuse to enforce the contract whether its knowledge comes from the statement of the party who was guilty of the illegality or whether its knowledge comes from outside sources. The court does not sit to enforce illegal contracts. There is no question of estoppel, it is for the protection of the public that the court refuses to enforce such a contract." Emphasis mine. Wilmer L.J.'s opinion of the raison d'etre of the rule with regard to unlawful contracts, as stated in Snell v. Unity Finance Co., Ltd. Supra, destroys any argument that the plea of res judicata is sustainable. On the contrary, it reinforces the point that we have a constitutional duty to interfere with the award. He said, "The principle with regard to unlawful contracts was stated in 1775 by Lord Mansfield in Holman v. Johnson, the objection that a contract is immoral or illegal as between plaintiff and defendant sounds at all times very ill in the mouth of the defendant. It is not for his sake, however, that the objection is ever allowed, but it is founded in general principle of policy, which the defendant has the advantage of, contrary to the real justice, as between him and the plaintiff by accident, if I may say so. The principle of public policy is this: ex dolo malo, non oratur actio. No court will lend its aid to a man who founds his cause upon immoral or illegal act, if from the plaintiff's own stating or otherwise, the cause of action appears to arise ex turpi causa, or the transgression of a positive law of this country. The court says he has no right to be assisted. It is upon that ground that the court goes, not for the sake of the defendant, but because they will not lend their aid to such a plaintiff. By parity of reasoning, this gross violation of the supreme law of our land, which has rendered an otherwise lawful contract unconstitutional, cannot be validated by the estoppel doctrine of residential judicata. Enrique Bangstool, Carey and another v. Ababio II and others, speaking through Ampia, JSC observed that estoppels of all kinds are subject to one general rule: they cannot override a statutory provision. Thus, where a particular formality is required by statute, no estoppel will cure the defect. Dr. Seth Twm, JSC as he then was. My lords, A judgment is final because it puts an end to the action by making an award of redress to a party, or discharge the other, as the case may be. That a summary judgment is a final judgment is too inveterate to be disputed today, and once a judge pronounces final judgment, then subject to the rules of court or any other statutory provision to the contrary, the judge becomes functus officio. It does not matter if subsequently, the court is differently constituted. Hence, notwithstanding the fact that the High Court has entered final judgment, it may grant stay of execution pending the hearing of a fresh action commenced by the party against whom a judgment was pronounced, against the party in whose favor the judgment was given under Order 42 Rule 49. The High Court may also grant a stay of execution pending the hearing of a civil appeal under Rule 27 of the Court of Appeal Rules, 1997, CI 19, or it may review the judgment under Order 39 of the High Court, Civil Procedure, Rules, 1954, LN 140A. The court may also correct clerical mistakes or errors arising from accidental slips or omissions in a judgment under Order 28 Rule 11. It may even set aside summary judgment under Order 14 Rule 11. My lords, in my view, a claim for damages for breach of contract will entitle the plaintiff to nominal damages only unless the plaintiff gives particulars of special damage. No particulars of general damages are ever ordered. General damage is such as the law will presume to be natural or probable consequence of the defendant's act. It arises by inference of the law and need not therefore be proved by evidence. Hence it may be averred generally. Special damage, on the other hand, is such a loss as the law will not presume to be the consequence of the defendant's act, but depends, at least, on the special circumstances of the case. It must therefore always be explicitly claimed on the pleadings. The law is clear that whenever damage of any kind is an essential portion of the cause of action, it is special damage, and as much certainty and particularity will be insisted upon, both in pleading and proof of damage, as is reasonable, having regard to the nature of the acts themselves by which the damage is done. As Bowen L.J. put it in Ratcliffe v. Evans, to insist upon less would be to relax old and intelligible principles. To insist upon more would be the vainest pedantry. My lords, one is reminded of the immortalized statement of Olenaje, as he then was, in Majolagby v. Larby and Ors, proof in law is the establishment of facts by proper legal means. Where a party makes an averment capable of proof in some positive way, example by producing documents, descriptions of things, reference to other facts, instances, or circumstances, and his averment is denied, he does not prove it by merely going into the witness box and repeating that averment on oath, or having it repeated on oath by his witnesses. He proves it by producing other evidence of facts and circumstances, from which the court can be satisfied that what he avers is true. Dr. Date ba JSC as he then was. The plain meaning of Article 181(5) would appear to be that where the government of Ghana enters into an international business or economic transaction, it must comply with the requirements, mutatis mutandis, imposed by Article 181 of the Constitution. Those requirements clearly include the laying of the relevant agreement before Parliament. The agreement is not to come into operation unless it is approved by a resolution of Parliament. It is clear that the purpose of the framers of the original provision was to ensure transparency, openness, and parliamentary consent in relation to debt obligations contracted by the state. These original provisions of 1969 Constitution were maintained unchanged in the 1979 Constitution as Article 144. It is in the 1992 Constitution that this long-standing provision on the giving and raising of loans is modified to include another category of contract, namely, an international business or economic transaction to which the government is a party. By analogy, one can legitimately infer that the purpose of the framers of the expansion of the provision was to ensure transparency, openness, and parliamentary consent in relation to this additional category of contracts also. This purpose, to my mind, is achieved by the plain meaning of the provision. It is also to be deduced from the stated purpose of the framers of the 1969 provision and the proposal in 1991, by the Committee of Constitutional Experts, to expand the ambit of the provision to cover the additional category of contract. Unfortunately, the report of the Committee of Experts, Constitution, on proposals for a draft Constitution of Ghana, 1991, which constituted the proposals out of which the 1992 Constitution emerged, does not provide any express comment on the purpose of the expansion of ambit. The expansion is proposed, without explanation or comment, in Clause 17(5) of Appendix M to the report. This appendix deals with economic and financial order. The proposal adds the following clause to the original provision: this article shall, with the necessary modifications, apply to an international business or economic transaction to which the government is a party as it applies to a loan. My interpretation of this proposal, which was, in substance, adopted by the Consultative Assembly which deliberated on the proposals formulated by the experts and is embodied in Article 181 of the current Constitution, is that international business or economic transactions are to be treated, mutatis mutandis, as the same as loan agreements, from the point of view of the requirements contained in Article 181. This, to my mind, means that an international business transaction or international economic transaction to which the government is a party must be submitted to Parliament for approval, even though the nature of the obligation embodied in such transaction is not one of debt. An international business or economic transaction include a business transaction between the government of Ghana and a company incorporated abroad. Even though Clause 5 of Article 181 enjoins Parliament to make the necessary modifications to Article 181, I do not interpret Clause 5 as rendering that clause ineffective until the parliamentary modifications to Article 181 have been made. Such statutory modifications are, to my mind, intended to assist the clarity of Clause 5 in the context of Article 181, but the clause has effect even before Parliament carries out its task. The agreement of this United Kingdom company to generate and supply electricity to the government of Ghana in Ghana was clearly a transnational transaction which qualifies for characterization as an international business transaction to which the government of Ghana is a party, within the meaning of Article 181(5). This constitutional provision, in my view, is a peremptory norm that has to be heeded by this court. To borrow from the language of public international law, it may be viewed as analogous to a jus cogens whose enforcement cannot be impeded by the normal rules. The Office of the Attorney General has a special responsibility in upholding the Constitution of this land, and shortcomings in that office can embarrass the state and the people of Ghana. This case comes within the exception to the principle formulated by Lord Denning in Golightly v. Ashrafai that generally where a point of law has not been raised in the trial court and the Intermediate Court of Appeal, it may not be raised in the final Court of Appeal. The Office of the Attorney General was obliged to raise this point of law, even if belatedly, in discharge of its obligation to uphold the Constitution of Ghana. I believe that this court, equally, is obliged not to refuse to consider a point of law directly relating, as on the facts of this case, to real issues relating to the interpretation and enforcement of the Constitution. The Supreme Court, of course, has power to consider matters not raised specifically in a ground of appeal. This is a power that it should liberally resort to where it concerns upholding the Constitution of this land. Key vocabularies from the case. 1 per Akufo JSC. Erudite. Aforesaid. Evince. Spectre. Offhand manner. force-fed into this appeal. Execrable. 2 per wood JSC. Oft-used omnibus ground. Threadbare. Salutary. Ex facie illegal. I am attracted to this argument. Been laid bare. Ex dolo malo non oratur actio. No court will lend its aid to a man who founds his cause upon immoral or illegal act. Extirpi causa. 3 per seth tuum JSC. Seminal point. Inveterate. Functus officio. Paucity of evidence. The immortalized statement. Dismally to quantify. Exigible. 4 per dateba JSC. Foreclosed by residential judicata. Non. Sequitur. Smacks. Attorney General VRS. Balkan Energy on Article 181 of the Constitution. Dr. Dateba JSC. The three main issues before the court were the definition of an international business transaction within the meaning and context of Article 181(5) of the Constitution, and can a government of Ghana contract with a Ghanaian legal person or entity ever be an international business transaction? If so, how are we to distinguish an international business transaction of a Ghanaian legal person from its other contracts with the government of Ghana? Are you able to formulate any clear indices or criteria? The interpretation of the court. The phrase international business or economic transaction to which the government is a party, if purposively construed, should not lead necessarily to the result that only agreements between entities resident abroad and the Ghana government can be embraced within the meaning of the term. Given the complexity of contemporary international business transactions, there will be transactions of such a clear international nature that they should come within any reasonable definition of an international business transaction, but which may have been concluded with the Ghana government by an entity resident in Ghana. In such a situation, our view is that the substance, rather than the form, should prevail. What we have just said begs the question of what international means. In this connection, we think that there is the need to combine both the nature of the business or economic transaction criterion and the parties criterion proposed by the plaintiff in his submission, in order to formulate a test for determining what transactions come within the ambit of Article 181(5) of the 1992 Constitution. Substance should rule, rather than form, and thus grasp the nettle. In our view, to give effect to the framers' purpose, there is need to imply into Article 181(5) an understanding that only major international business or economic transactions are to be subject to its provisions. We do, however, agree with the defendants that Parliament needs to exercise its legislative power in relation to Article 181(5) in order to clarify which transactions are to be viewed as major. The interpretation that the international business or economic transactions that come within the ambit of Article 181(5) should be limited to only major ones is a purposive one. In Asare v. Attorney General, the court pointed out that there is a distinction between the objective and the subjective purposes of a constitution or statute. The court there said, the subjective purpose of a constitution or statute is the actual intent that the authors of it, namely, the framers of the constitution or the legislature, respectively, had at the time of the making of the constitution or the statute. The objective purpose is not what the author actually intended but rather what a hypothetical reasonable author would have intended, given the context of the underlying legal system, history, and values etc. of the society for which he is making law. This objective purpose will thus usually be interpreted to include the realization, through the given legal text, of the fundamental or core values of the legal system. One of the values of the 1992 Constitution is the promotion of probity, accountability and fidelity. What then is the meaning of international in this context? We think that a business transaction is international within the context of Article 181(5), where the nature of the business which is the subject matter of the transaction is international in the sense of having a significant foreign element or the parties to the transaction, other than the government, have a foreign nationality or reside in different countries or, in the case of companies, the place of their central management and control is outside Ghana. The word significant is used in the above definition to denote the fact that the foreign elements or contacts that lead to a judgment of internationality in relation to a transaction have to be subjected to a qualitative assessment before reaching that judgment. The significance is in relation to the purpose of Article 181(5). This qualitative assessment is important in separating business transactions which are international within the meaning of Article 181(5) from those that are not. As to the meaning of business, it means where a transaction is commercial in nature, or pertains to or impacts on the wealth and resources of the country. It would be a business or economic transaction and a subject of interest in any examination of Article 181(5). We interpret transaction in his context as meaning a series of agreements or acts united by their purpose of attaining the project objective of the parties to it. Some key elements to look out for in such transactions include: there must be a significant foreign element in the transaction. Secondly, the entity must be wholly owned by a foreign entity, incorporated in a foreign country. Thirdly, the personnel and control of the management of the company is in foreign hands. Fourthly, the PPA contains clauses providing for international commercial arbitration, and then clauses associated with foreign investment transactions. In the referral case to the Supreme Court, Attorney General v. Balkan Energy, Sophia A. B. Akufo, JSC as she then was held the following. According to the Merriam-Webster Dictionary of Law, 1996, to interpret is to explain the meaning of something in order to determine intent. For the purposes of interpretation, intent more often than not also includes scope. Now, in Attorney General v. Faro Atlantic Co., Ltd., Supra, this court expounded the meaning of the expression an international business or economic transaction to which the government is a party, as used in Article 181(5), within a particular context, i.e., an agreement between the government and a foreign company, where, in a subsequent matter, a party contends that the scope of the provision is broader and covers an agreement between the government and a domestic party of a certain type, then the intent and scope of the provision once again falls to be determined, not by the High Court, but by the constitutionally clothed court, the Supreme Court. The matter is not merely one of applying the provisions of Article 181(5) in accordance with and along the lines of the previous interpretation. Now, as was made patently clear in the case of Ex parte Electoral Commission, the remedies available to the Supreme Court, when exercising its supervisory jurisdiction under Article 132, are not limited to the issuing of the conventional writs of certiorari, mandamus, prohibition, etc. We also have the power to issue orders and directions as shall be necessary to prevent illegalities, failure of justice and needless delays in the administration of justice, for the purpose of enforcing or securing the enforcement of our supervisory power. Additionally, under Article 129(4) for the purposes of hearing and determining a matter within its jurisdiction and the amendment, execution, or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority, expressly or by necessary implication given to the Supreme Court by this Constitution, or any other law, the Supreme Court shall have all the powers, authority and jurisdiction vested in any court established by this Constitution or any other law. Martin Alamisi Amadou VRS, Attorney General, Waterville Holdings, and Alfred Ugbasi Wayam, same on Article 181 of the Constitution. Date Ba JSC. The words of Akwak JSC, as he then was, delivering the ruling of the Supreme Court in Adu Moatu v. Adu Tuamtu are helpful in determining the jurisdiction of the court. He there said, at p. 167, "My lords, the original jurisdiction vested in the Supreme Court under Articles 2, 1, and 131 of the 1992 Constitution to interpret and enforce the provisions of the Constitution is a special jurisdiction meant to be invoked in suits raising genuine or real issues of interpretation of a provision of the Constitution, or enforcement of a provision of the Constitution, or a question whether an enactment was made ultra vires Parliament or any other authority or person by law or under the Constitution. This special jurisdiction is not meant to usurp or to be resorted to in place of any of the jurisdictions of a lower court. In other words, where our said jurisdiction has been invoked in an action which properly falls within a particular cause of action at a lower court, this court shall refuse to assume jurisdiction in that action, notwithstanding the fact that it has been presented as an interpretation or enforcement suit or both. 4. A large number of actions which fall within specific causes can be presented in the form of interpretation or enforcement actions or both. In this context, an issue that emerges strikingly for constitutional interpretation is the extent to which the nullity of international business or economic transactions in consequence of their non-compliance with Article 181, 5, of the 1992 Constitution affects restitutionary rights under the common law. To put the issue another way, if an agreement to perform certain acts comes within Article 181, 5, but has not yet been submitted to Parliament for its approval, is it lawful for the executive to bypass the obligation of Article 181, 5, by requesting the acts contemplated under the contract to be performed by its partner anyway, and then make payment to the partner under claims for restitution? In principle, it would appear to be clearly against public policy to allow such evasion by the executive of its constitutional duty. Article 181, 5, thus needs to be construed purposively to invalidate claims to restitution in such situations. This dimension of this case is what brings it within the exclusive jurisdiction of this court, under Article 130 of the 1992 Constitution. What is in issue is whether there is a penumbra effect of Article 181, 5, such that rights and obligations which are devised to enable an evasion of the provisions duty can equally be nullified. This is a task of constitutional interpretation for this court and not for the High Court. The right to restitution may arise in relation to a situation where the defendant has acquired a benefit from or by the act of the plaintiff. See Goff and Jones, The Law of Restitution, 6th ed., 2002. The plaintiff's ground of recovery may be that he was mistaken, that he was compelled to do what he did, that he acted out of necessity, that the consideration for his payment had wholly failed, or that the defendant had freely accepted the services which he had rendered or the goods which he had delivered. The last but one situation in this list of situations is what is relevant on the facts of this case. In other words, has the state, i.e., the first defendant, freely accepted services rendered by the third defendant? If so, does the Constitution permit the state to make payment for those services? In City and Country Waste Limited v. Accra Metropolitan Assembly, this court explained the common law approach to restitution in relation to illegal contracts as follows. There is a low-ng standing approach in the English common law, dating back to the 18th and 19th centuries, according to which where a contract is found to be illegal, the benefits conferred under it are not recoverable. The decided cases have tended to deal with the recovery of money paid or property transferred under an illegal contract. But even this traditional English approach was subject to exceptions. The two main exceptions to the English general rule that a party cannot recover a benefit conferred on the other party under an illegal contract are, first, where the parties are not in pari delicto, and, second, where a party to an executory contract repents before performance. In the same case, the Supreme Court injected some flexibility into the received English common law rules. This is what the court said: The next issue arising therefore is whether the plaintiff is not in pari delicto with the defendant according to the orthodox English authorities on the issue. A review of the English case law reveals that, in assessing the fault of the parties, the law adopts a rather technical approach, according to which recovery is allowed only where a plaintiff can demonstrate that he or she was induced to enter into the illegal contract by the fraud, duress, or oppression of the other party, or that he or she was ignorant of a fact that rendered the contract illegal, or that he or she belonged to a vulnerable class protected by statute. By way of illustrating the last category, the words of Lord Mansfield in Browning v. Morris may be highlighted. Where contracts or transactions are prohibited by positive statutes, for the sake of protecting one set of men from another set of men, the one, from their situation and condition being liable to be oppressed and imposed upon by the other, there, the parties are not in pari delicto, and in furtherance of these statutes, the person injured after the transaction is finished and completed, may bring his action and defeat the contractee. We do not think that we ought in this court to be constrained excessively by the weight of the English case law in finding a just outcome in this case. Rather, we are encouraged to develop Ghanaian law in this area by some of the ideas contained in the English Law Commission's consultation paper number 154 on illegal transactions, the effect of illegality on contracts and trusts. This consultative paper, after an extensive and erudite review of the complex English law in the area, concludes as follows, at p. 91. We have said that we believe that there is a continued need for some doctrine of illegality in relation to illegal contracts, and that, in certain circumstances, it is right that the law should deny the plaintiff his or her standard rights and remedies. However, we have also explained how, in some situations, we believe that the plaintiff is being unduly penalized by the present rules. This injustice would seem to be the inevitable result of the application of a strict set of rules to a wide variety of circumstances, including cases where the illegality involved may be minor, may be wholly or largely the fault of the defendant, or may be merely incidental to the contract in question. We consider that the best means of overcoming this injustice is to replace the present strict rules with a discretionary approach, under which the courts would be able to take into account such relevant issues as the seriousness of the illegality involved, whether the plaintiff was aware of the illegality, and the purpose of the rule which renders the contract illegal. The adoption of some type of discretionary approach has the support of the vast majority of academic commentators in this area, and it is the approach which has been followed in those jurisdictions where legislation has been implemented. Moreover, we have not been able to devise a new, enlightened regime of rules that would provide satisfactory answers to all disputes involving illegal contracts. In our view, a balancing of various factors is required so that, put quite simply, the law on illegal contracts does not lend itself to a regime of rules. We have decided to adopt this structured discretionary approach to the resolution of issues arising from illegality of contracts. The approach is to be fleshed out on a case-by-case basis, on the facts of the present case, balancing the need to deny enforceability to the contract sued on by the plaintiff against the need to prevent the unjust enrichment of the defendant, and, considering that in relation to the defendant's non-compliance with the statutory provisions binding on it, the plaintiff was not in pari delicto in a broad sense, we have come to the conclusion that the plaintiff must be paid reasonable compensation for the services it rendered to the defendant. Thus, even assuming that the second and third defendants are not in pari delicto with the first defendant in the breach of Article 181, the fact that the norm breached is a constitutional provision, in contradistinction to breach of an ordinary statute, is a relevant consideration. Clearly there should be less room to award a restitutionary remedy where the breach is of a constitutional provision. A contract which breaches Article 181, 5, of the Constitution is null. and void and therefore creates no rights. It should not be legitimate to evade this nullity by the grant of a restitutionary remedy. Although one accepts the cogency of the argument that there is need to avoid unjust enrichment to the state through its receipt of benefits it has not paid for, there is the higher order countervailing argument that the enforcement of the Constitution should not be undermined by allowing the state and its partners an avenue or opportunity for doing indirectly what it is constitutionally prohibited from doing directly. The supremacy of the Constitution in the hierarchy of legal norms in the legal system has to be preserved and jealously guarded. Thus, the flexibility that the Supreme Court introduces in the CCWL case is to be exercised sparingly in the case of breaches of the Constitution. The requirement that international business contracts to which the government is a party should be approved by Parliament has a purpose, and it should be made clear to government and its partners that non-compliance with the requirement, directly or indirectly, will have consequences. We are accordingly inclined to the view that, where Article 181(5) has been breached, a restitutionary remedy would be in conflict with the Constitution and therefore not available. Therefore, the interpretation given to Article 181(5) of the Constitution covers restitutionary claims connected to contracts or agreements within the ambit of the provision. Also, on the issue of capacity, the court held that the fact that the Attorney General has brought a civil action on a particular issue cannot derogate from a citizen's right under Article 2(1) of the 1992 Constitution to seek a declaration and consequential orders from the Supreme Court in relation to the same issue if it involves any act or omission which the citizen alleges to be inconsistent with, or in contravention of, a provision in the Constitution. What is necessary for the citizen to do is to establish that he or she comes within the parameters laid down in Articles 2(1) and 131. If he or she does this, the mere fact that the Attorney General is conducting litigation in the High Court which is linked to the subject matter of his or her action will not ordinarily be a bar to the action. Our preferred locus clas sicut on the original jurisdiction of this court, buttressing the position adopted above, remains the words of Ananjaye, in Republic v. Special Tribunal, X. Part Echoes a 1980 GLR 592 at 605, where he said of a previous provision in pari materia, with the current provisions that, from the foregoing dicta, we would conclude that an issue of enforcement or interpretation of a provision of the Constitution under Article 118(1)(a) arises in any of the following eventualities. A. Where the words of the provision are imprecise or unclear or ambiguous. Put in another way, it arises if one party invites the court to declare that the words of the article have a double meaning or are obscure or else mean something different from or more than what they say. B. Where the rival meanings have been placed by the litigants on the words of any provision of the Constitution. C. Where there is a conflict in the meaning and effect of two or more articles of the Constitution, and the question is raised as to which provision should prevail. D. Where on the face of the provisions, there is a conflict between the operation of particular institutions set up under the Constitution, and thereby raising problems of enforcement and of interpretation. On the other hand, there is no case of enforcement or interpretation where the language of the article of the Constitution is clear, precise, and unambiguous. In such an eventuality, the aggrieved party may appeal in the usual way to a higher court against what he may consider to be an erroneous construction of those words, and he should certainly not invoke the Supreme Court's original jurisdiction under Article 118. Again, where the submission made relates to no more than a proper application of the provisions of the Constitution to the facts in issue, this is a matter for the trial court to deal with, and no case for interpretation arises. JSC continued with the judgment of the court in the current case by looking at the following. 1. Role of counsel in conducting cases in the law courts. even though the role of counsel in representing his client is mainly to ensure that his client gets the best of legal representation within the scope of his instructions, there is a corresponding duty on counsel to ensure that his conduct is within the framework of standards of professional etiquette and conduct for lawyers as stipulated in rules made for that purpose as contained in Section 23 of the Legal Profession Act, 1960. Act 32. Even though lawyers owe a duty to their clients, they also in a wider sense owe a general duty to the country Ghana and to their consciences as well as to their professional rules of etiquette and standard. The second and third defendants, after their initial disagreements about their entitlements, later entered into an alliance to create, loot, and share the resources of this country as if a brigade had been set up for such an enterprise. It is my respectful opinion that, no matter what the monetary attractions are, every counsel owes a duty to the ethics of the legal profession and to his own conscience to ensure that whatever claims are pursued on behalf of his client are not only legitimate, lawful, just and legal, but reasonable under the circumstances of the case. It is in this respect that I consider it worthwhile to refer to the unanimous decision of this Court in the consolidated case of Republic v. High Court, Kumasi, ex parte Bank of Ghana, Mr. Kwesi Amisa-Arthur and Franklin Belny, applicants, Rev. Rocher de Graft Sifa and Ernest Kwasi Niam Asiedo, interested parties, and Republic v. High Court, Kumasi, ex parte Bank of Ghana, Mr. Kwesi Amisa-Arthur and Franklin Belny, applicants, Samuel Gyamfi and Ors, interested parties, where the court expressed similar sentiments about the conduct of lawyers of the applicants, therein, Bank of Ghana, which led to default judgment being granted against them. In view of the seriousness which this court attaches to this phenomenon which has crept into our legal practice, I would quote in extenso from the said ruling as follows. Due to the gargantuan nature of the claims against the applicants, one would have expected a much more diligent and fast approach towards the handling of the suit. We would be very much surprised if the external solicitors of the first applicants is a one-man chamber such that with his incapacitation, work in his office automatically came to a halt. Even if that is the situation, we expect the legal department of the applicants to have entered appearance in the meantime to ensure that the timelines provided under the rules of procedure are complied with. We have taken time to delve into this matter because we are of the considered opinion that the time has indeed come for this court to comment on the manner in which legal representation of state and parastatal interests are handled in our law courts. The quality of legal representation of these institutions leaves much to be desired. Professionals of whatever type engaged by those to whom their services are required, need to offer dedicated, committed, and competent services to those who engage them. There is a saying that to whom much is given, much is expected. To have the privilege of being appointed as external solicitors of the first applicants is no mean responsibility, but one that has to be discharged with diligence and competence. Whilst we have not been happy with the quality of legal service that was rendered the first applicants in the High Court, which unfortunately led to the default judgment being granted against them, we note with appreciation the sentiments which were expressed by the Court of Appeal in the case of Agyeman v. Ghana Railway and Ports Authority, Takoradi, where the court, in expressing its disgust in the conduct of a solicitor in the public service whose conduct led to the grant of default judgment against a public entity, commented thus: "We would like to make the point that lawyers engaged in the public service and who are called upon to represent public institutions in lawsuits have the responsibility to ensure that public funds are not improperly expended through their default, and that they must exhibit the same degree of diligence as is required of a private practitioner. There cannot be one standard of professional conduct for the lawyer in the public service and another for the lawyer in private practice. 2. Role of trial courts in adjudication of cases before them. The duty of a trial court judge or magistrate is to ensure that cases brought up before them are not only legitimate, but based on sound principles of law. In other words, a trial court must ensure that claims brought before them are legal, constitutional, and based on pleadings. A trial judge or magistrate is not to accept hook, line, or sinker claims brought before it on the basis that the defendants have not put up a defense. There should be no indecent haste on the part of a trial court to rush to deliver judgment on account of default of pleadings. This is because this court has had occasion to comment on apparent collusion that sometimes exists between plaintiffs and defendants. See intituled African Automobile, Appellant v. the Attorney General, Respondent where the President of this court, Dateba JSC, in a unanimous decision of the court accepted and applauded the learned trial judge who, despite attempts by the respondents therein to accept that there was a binding contract, concluded that no contract had been formed on the basis of Exhibit A, that was the contract documents in that case, and both the Supreme Court and the Court of Appeal affirmed the decision of the trial judge, Torkana J. MRS, as she then was. It is therefore important that trial courts must be on the alert to prevent cases where collusion can occur and ensure that they act as watchdogs not only of the public purse but also protective of the rights of any person who appears before them. The courts of law, established under the Constitution 1992, must not be used by anybody or group of persons to unlawfully or illegally enrich himself or themselves to the disadvantage of any person or the state. Trial courts must, as a control measure, always ensure that claims or endorsements in actions brought before them, especially where default applications for judgment arise, are scrutinized thoroughly to prevent collusion and or abuse of the judicial system. In this regard, even an ex parte application, though one-sided, ought to be scrutinized by the court and must be granted only if it satisfies the conditions lawfully and legally required to be proven or established. 3. Viewers should note the commendation remarks passed by said JSC on the vigilante role played by the plaintiff and thereby calling on civil society group and others to protect the public purse and interests. Martin Alamisi Amadou VRS, Attorney General, Isafatan SA, and Ananaji Ferson, same on Article 181 of the Constitution. Dr. Dateba JSC. The court reaffirmed the above position on the capacity of a citizen in the Amadou case. Supra, and further emphasized that the plaintiff, as a citizen of Ghana, is entitled as of right to challenge in this court any act or omission which is inconsistent with, or in contravention of, a provision in the Constitution, even if the Attorney General is also in court against the same defendant in a civil case. This right follows from the principle established in Sam. No. 2, v. Attorney General that, in an action under Article 2(1) to enforce or interpret the Constitution, as distinct from an action to enforce a fundamental human right under Article 33(1), a party need not show a personal interest in the litigation. A citizen's duty under Articles 3, 4a, and 41b, to defend the Constitution are a sufficient interest to invoke the Supreme Court's special jurisdiction. Under Article 2(1), the considerations which Parliament needs to take into account in approving a project loan agreement will not necessarily be the same as those applicable to what the second defendant calls a project implementation agreement. A ready illustration of the issue under discussion is provided by taking judicial notice of the widespread media reports that the government of Ghana signed in 2012 a $3 billion loan agreement with the Chinese Development Bank. It was signed after due approval of it by Parliament. The loan is meant to finance several different projects. Surely it is not reasonable to infer from the fact of approval of the loan agreement that Parliament has also approved the details of the range of different project agreements which had not yet been worked out as of the date of the approval of the loan. A distinction therefore clearly needs to be made between the loan agreement and the agreements of projects to be financed by the loan. This Chinese loan illustration shows that Parliament has a legitimate policy interest in scrutinizing and approving project implementation agreements, even if it has already approved the loan from which they are to be financed. The terms and issues in these kinds of agreements are not identical and therefore deserve separate scrutiny and approval. In this connection, see Dateba JSC, examination of the purpose of Article 181(5), set out in the Faro-Atlantic case, Supra. It is evident that this purpose of ensuring transparency, openness, and parliamentary consent in relation to international business transactions or international economic transactions to which the government is a party deserves to be applied as much in relation to the so-called implementation agreements as to project loan agreements. In other words, the purposive approach insisted upon by the second defendant, when reasonably applied, should lead to the conclusion that an international business or economic transaction to which the government of Ghana is a party should not cease to be treated as such, under Article 181(5), simply because activities under it are to be financed under a loan agreement that has already been approved by Parliament. Orders made under Article 2(2) are to be distinguished from those made pursuant to this court's supervisory jurisdiction under Article 132 of the Constitution. Orders made under Article 2(2) may look similar to those under Article 132, but they are not subject to the limits of the prerogative writs and orders. The purpose of Article 2(2) is to enable full effect to be given to declarations of unconstitutionality made by this court under Article 2(1). Accordingly, it has to be interpreted liberally to give this court wide power to ensure the supremacy of the Constitution. The time limits, for example, applicable to the prerogative writs under the rules of court do not, therefore, apply to orders made under Article 2(2). What we are saying, flowing from the provision of Article 2(2), is that the Supreme Court can, under the provision, order the setting aside or nullification of any rulings, judgments, orders, or contracts needed to give effect to a declaration it has made under Article 2(1). Once this court assumes its special original jurisdiction on the basis that there is a real and genuine issue for interpretation of the Constitution, it implies that any high court that has purported to interpret the same provision lacked jurisdiction. Embedded in the common law principle that an agent is not liable for acts done on behalf of his or her principal is the notion that the act or omission in question is that of the principal and not of the agent. This notion holds good, even in the constitutional context, unless there is an express overriding of it, to the extent that the lawful attorney is only a conduit through which the principal acts, and to the extent that the acts complained of by the plaintiff were all acts performed by the third defendant in his capacity as lawful attorney. The Roman poet Horace in one of his odes declares, dulce et decorum est pro patria mori. Literally translated, this means it is sweet and honorable to die for one's country. See this quote by his lordship to commend the plaintiff. Per Dotsa JSC concurring judgment. Trial courts must therefore hasten slowly when issues of constitutional interpretation are raised before their courts, and unless the constitutional provisions in issue have been overflogged by this court, the necessary reference must be made to the Supreme Court for it to assume its jurisdiction. It is only by strict adherence to these basic principles that the jurisdictional limits set in the Constitution 1992, the Courts Act, 1993 Act 459, and other statutes will be honored in their observance than in their breach. Felix Clomega VRS, Attorney General and Ghana Ports and Harbors Authority and 2 oars, same on Article 181(5), but now on the definition of government. Dr. Dateba JSC. The 3 issues before the court were whether and to what extent government under Article 181(3) includes public authorities the cost of whose operations and debt obligations constitute a charge on the public accounts of Ghana. Whether the agreement entered into between second and third defendants is an international business transaction within the meaning of Article 181, and thus null, void and unenforceable for lacking parliamentary approval, and whether the concession entered into between second and fourth defendants is an international business transaction within the meaning of Article 181, and is thus null, void and unenforceable for lacking parliamentary authorization by the court to subject statutory corporations with commercial functions to the parliamentary approval process prescribed in Article 181(5), would probably increase the weight of Parliament's responsibilities in this regard to an unsustainable level. Accordingly, it is reasonable to infer that the framers of the 1992 Constitution did not intend such a result. Thus, in our view, government in the context of Article 181(5) should mean, ordinarily, the central government and not operationally autonomous agencies of government, where an agency has a separate legal personality distinct from central government. It usually comes under sectoral ministerial supervision. The board of the corporation and the appropriate ministry should then exercise oversight over its international business or economic agreements. That oversight should be exercised within the context of the procurement laws of this country. Parliament would be sucked into unnecessary minutiae if it were to have the function of approving the international business or economic agreements of statutory corporations. That is why government, in the context of Article 181(5), should be interpreted purposively to exclude corporations such as the second defendant. This interpretation is the only reasonable one, if one reads the Constitution as an organic whole. As Aqua JSC, as he then was, said in Mensa v. Attorney General, I think it is now firmly settled that a better approach to the interpretation of a provision of the Constitution is to interpret that provision in relation to the other provisions of the Constitution so as to render that interpretation consistent with the other provisions and the overall tenor or spirit of the Constitution. An interpretation based solely on a particular provision without reference to the other provisions is likely to lead to a wrong appreciation of the true meaning and import of that provision. Thus, in Benyon, Constitutional Law of Ghana, 1962, at p. 283 it is explained that it is important to construe an enactment as a whole, since it is easy, by taking a particular provision of an act in isolation, to obtain a wrong impression of its true effect. The dangers of taking passages out of their context are well known in other fields, and apply just as much to legislation. Even where an act is properly drawn, it still must be read as a whole. Indeed, a well-drawn act consists of an interlocking structure, each provision of which has its part to play. Warnings will often be there to guide the reader, as for example, that an apparently categorical statement in one is subject to exceptions laid down elsewhere in the Act, but such warnings cannot always be provided. This court should, however, not lay down an absolute rule. If, on the facts of a particular case, central government were found to have made a particular statutory corporation its alter ego under the circumstances of that particular case, the possibility of holding that statutory corporation comes within Article 181(5) should not be ruled out. However, on the facts of this case, and given the nature of the functions of the second defendant, we would hold that it does not come within the ambit of Article 181(5). In court, in the case of Bridas Sapic v. Government of Turkmenistan, distinguished between the alter ego doctrine and the principles of agency as follows. Courts occasionally apply the alter ego doctrine and agency principles as if they were interchangeable. The two theories are, however, distinct. Under the alter ego doctrine, a corporation may be bound by an agreement entered into by its subsidiary regardless of the agreement's structure or the subsidiary's attempts to bind itself alone to its terms, when their conduct demonstrates a virtual abandonment of separateness. This is due to the doctrine's strong link to equity, that the alter ego doctrine can be invoked only where equity requires the action to assist a third party. The laws of agency, in contrast, are not equitable in nature, but contractual, and do not necessarily bend in favor of justice. Courts are thus comparatively free from the moorings of the parties' agreements when considering whether an alter ego finding is warranted. Alter ego determinations are highly fact-based, and require considering the totality of the circumstances in which the instrumentality functions. No single factor is determinative. This should be apparent from the extensive list of circumstances that courts have developed to guide alter ego determinations. His Lordship quoted Breda's 12 private law factors commonly in making a corporate alter ego determination. 1. The parent and subsidiary have common stock ownership. 2. The parent and subsidiary have common directors or officers. 3. The parent and subsidiary have common business departments. 4. The parent and subsidiary file consolidated financial statements. 5. The parent finances the subsidiary. 6. The parent caused the incorporation of the subsidiary. 7. The subsidiary operated with grossly inadequate capital. 8. The parent pays salaries and other expenses of subsidiary. 9. The subsidiary receives no business except that given by the parent. 10. The parent uses the subsidiary's property as its own. 11. The daily operations of the two corporations are not kept separate. 12. The subsidiary does not observe corporate formalities. He further cited Chief Judge Edith Jones in the same case, where he gave 3 more private law factors to identify, as follows. 1. Whether the directors of the subsidiary act in the primary and independent interest of the parent. 2. Whether others pay or guarantee debts of the dominated corporation. And 3. Whether the alleged dominator deals with the dominated corporation at arm's length. Additional factors directed were: 1. Whether state statutes and case law view the entity as an arm of the state. 2. The source of the entity's funding. 3. The entity's degree of local autonomy. 4. Whether the entity is concerned primarily with local, as opposed to statewide, problems. 5. Whether the entity has the authority to sue and be sued in its own name. And 6. Whether the entity has the right to hold and use property. In all, Dateba JSC concluded by stating, whilst we do not consider that the facts of the case before us can reasonably be interpreted as falling within the notion of an agency of government constituting an alter ego for the government, we nevertheless consider that the idea that a statutory corporation, though legally distinct from the government, can in appropriate circumstances be held to be an alter ego of the government is one that should serve the useful purpose of an exception to the general rule on the basis of which this case has been determined. In appropriate future cases, the doctrine of alter ego could be adopted and adapted to serve the purposes of Ghanaian law, after due and rigorous review. The Ghanaian doctrine need not have an umbilical cord to the case cited above. That case merely provides an illustration of how to construct an exception to the primary interpretation of Article 181(5) set out above. The mischief that the doctrine would be helpful in suppressing is the possibility of the central government seeking to evade parliamentary scrutiny and approval of its qualifying agreements by getting a statutory corporation to enter into international business or economic transactions that would otherwise fall within the ambit of Article 181(5). The alter ego doctrine has the potential for development to respond to this loophole. In short, Article 181(5) is to be interpreted as follows. Generally, the contracts of statutory corporations are not within the ambit of the provision. However, in exceptional circumstances, through the application of a customized Ghanaian version of the doctrine of alter ego. The contracts of a Ghanaian statutory corporation could be brought within the intendment of Article 181(5). This is where we will end our episode 2 on Acme Ghanaian court decisions worth noticing. We humbly seek you all to write down your comment to help us feed you better, and please, do not forget to subscribe to this channel to join the community, like this video, share the link to all, and feel free to contact us via email, thelaw360gh@gmail.com. Thank you and enjoy the rest of your stay with us. The Law 360 GH channel, solemn oneness to imbibe the law.